Right, good morning everyone. This is a meeting of the Licensing Act 2003 Subcommittee of the London Borough of Newham. The meeting will be broadcast or recorded live and can continue to be so available on the council as usual. Please just bear with me a second. Okay, in accordance with the Members' Code of Conduct, the three councillors on the committee today are required to declare any relevant interests on any matter being considered at this meeting. My name is Councillor Tony Wilson and I have nothing to declare.
Councillor Jane Loftus, I declare.
Councillor Simon Rush, I have nothing to declare.
Okay, I will now move on to introductions. My name is Councillor Tony Wilson. I represent Beckton Ward and I will be chairing the meeting throughout. Councillor Lofthouse.
Councillor Jane Lofthouse, representing Plaistow South.
Councillor Rush.
Councillor Simon Rush, representing Plaistow West and Canning Town East.
Case officer, please.
Colin Hunt, licensing.
Yes, and if you'd like to introduce yourselves, authorities.
Simon Stuart May, Metropolitan Police Licensing for Newham and Waltham Forest.
Anne-Marie Mark, Council for the Police.
Thank you.
PC Donna Wilcox, Central.
Thank you.
PC Kirian Tilly at Licensing.
Thank you very much. And finally, licensing.
Yes, good morning, members. I'm David Daz. I'm counsel for the premise licence holder. There are two premise licence holders, so in fact, I'm acting for both, but I'll have very little to say for the landlord. And who are present with me, I'll let them introduce themselves.
Sylvia Lutaya.
You're going to have to speak up.
I'm Sylvia Lutaya for Pier 1.
From Pier 1. Say that, Christine.
We can write it down if need.
Yes.
Robert Kavuma, DPS, designated premises supervisor, Pier 1.
Thank you.
William Lule, Pier 1.
Pier 1.
Thank you.
Pier 1.
We have some visitors at the back. Would you like to introduce yourselves, please?
I'm Sheila Roberts, the Director for Licensing and Regulatory Services.
Thank you.
David King, Team Leader for Licensing and Trading Standards.
Okay, I'm going to briefly run through the procedures. The licensing case officer will present their report. We then move on to the representations from the responsible authorities, for example, police, trading standards, environmental health, etc. Members can seek clarifications, and so can the applicant or their representatives on any matters. Have representations today for the police and police only. Finally, members may pass a resolution to deliberate in private and exclude the press and public, including the parties and their representatives. The legal and a clerk advisor will remain with us with the procedures and law. When the decision has been reached, the meeting will be reconvened and the decision of the subcommittee will be announced in public. Full written copies of the decision sent to the applicant and licence holder or responsible authorities and interested parties, usually within 5 working days. Parties who have taken part in the hearing may appeal against the decision to the Magistrates' Court within 21 days. As this is an administrative hearing under the 2003 Act, we are not trained lawyers. Please remember that, everyone. And so rely on legal advice from our legal department, today represented by
Mr. Ranatunga. I'm a barrister external to the council.
Thank you. I would like to also inform all parties that we base our decisions on written and oral submissions. The clerk will take minutes of the meeting. Please introduce yourself, clerk.
Christine Alsacker, Newham Democratic Services.
Okay. If anyone in the chamber wishes to ask a question during the meeting, I will ask them to raise their hand and wait. Please wait to be invited to speak. I would ask that all mobile phones are on silence or switched off. And right now, I would like now to invite the case officer to present their report.
Thank you. Thank you, Chair.
Madam Chair, sorry, how would you like me to address you, Chair?
Yeah, it's fine.
Chair.
Yes.
I would like to set up our recording so we get the officer's report recorded. So it might be that if you are going to allow us to do that, well, all the time to do that, then I'd ask if we could adjourn now so we could get the officer's report also recorded, please.
Sorry, could you just bear with me one moment? Sorry, Simon.
No, it's your point.
All right.
I wasn't sure if you.
Good morning, Chair.
Good morning.
Insofar as recording of the hearing will be concerned, the police have previously confirmed and have made representations to the local authority insofar as the details of those, the details of the investigation is concerned. So whilst this hearing ultimately relates to a licensing breach, the information which it relates to concerns an ongoing police investigation. Very, very serious crime. So it has been confirmed to us previously that all that is really relevant, and I'm told at least it's been placed in green in the bundle, will not be broadcasted. Highlighting that to the committee now because I don't see the point in Mr. Dadd setting his cameras up. As a side issue, I feel that the committee needs to be very careful when it makes a finding on whether it should be permitted. And when I say it, the recording of individuals in this room is be permitted. The officers that are sitting next to me obviously form part of the investigation or have formed part of the investigation, and they are privy to information relating to that investigation. So their identity should not be made public. Thank you.
So I don't know, Chair, if I can come in at this stage before you hear from Mr. Dadds. I think what you outlined at the outset is there's two issues before we start, really. One is there are some restricted papers that this committee has not yet read, so there needs to be some time for that to happen.
Yeah.
And secondly, there's this issue of the videoing by the premises licence holder of the hearing. Can I suggest, I mean, you have heard from the police, but where we'd reached with it was I'd taken soundings both from Mr. Dadds and from Miss Martins. Can I suggest we take an adjournment to consider that and hopefully come to some consensus? If there continues to be an issue with it, then you can continue to hear the point openly. But at this stage, I would suggest that you deal with that through an adjournment first and then deal with it,
right?
Rather than hearing it all out now.
Right. Okay.
I see that Mr. Dadds wants to say something now.
Just briefly.
And briefly hear from him, but then I would suggest you adjourn to deal with both of those issues.
Okay. Thank you. Thank you.
Yes. Chair, thank you for, I won't rehearse all my points, but just in reply summary, of course, we are all alive to the fact that there's a criminal investigation. I think there needs to be a distinction between an investigation of, say, a licensing breach and an investigation into the sexual assault or spiking. In relation to the alleged sexual assault, obviously it'll be sub judice, so we've got to be careful what is said or done in public. But it doesn't mean, and we can be alive to the fact, all of us here who will speak won't mention names. You won't have should not have recordings being played in public. And I think we're all alive to that. But nevertheless, in relation to this review, which has been made public, press have reported on it, we have something to say about it in public because it's been published in public. We believe the police's conduct is unbecoming, unprofessional, and they've lied. And we want to make sure that the public do get to hear that. And I think it's important that these proceedings are not just washed away. We can be very careful how we proceed, but of course we want to make sure the public do hear the parts which can be heard in public. Those parts that can't, then we have no objection to, but it's in your good hands because we know that you will be fair, but we're being very clear that police have lied and we want to make sure we can put that on the public record that everyone can see it.
Right, thank you, David. Now, you are also aware that this is being recorded and it will be published on YouTube. So with that being said, I am going to adjourn the meeting. If you can all please go outside. I need to speak.
I don't know, Chair, whether we can say it's 10:25 now. If we say we expect to be back by 11.
Yes.
And we'll keep the parties in.
Can we just check that the documents we've sent, we all have the same papers, because that would be helpful before we come back and then suddenly we're missing something. So
supplementary that you sent.
Yes, because I haven't seen what you've been given as a supplementary. I wonder if I could have a copy, have a look.
Sent over.
Yes, is that, and there was so you have what we sent over yesterday morning before 10 or thereabouts, and there was one page missing.
I've got it here and I was going to bring that up at the end.
But that's very clear.
It has to be.
That come in last night.
Yes, yes,
It's going to table that.
yes, it was the second, on the correspondence clip, Chair. There is the first email, but the second page was missing, so I just sent it over. When I was going through it yesterday, I realised there was an omission of one sheet.
Right.
That's been sent over here.
Right,
So,
thank you.
Don't know if you want that now or do you want to
It will be good if you
Robert?
hand it out now.
Sorry,
Has the police seen it?
police hasn't seen it.
Right.
Madam Chair, that's been an ongoing difficulty, really.
Their email.
I hear Mr. Dad, let me finish my submissions. I hear Mr. Dad says that he has regard for all of the facts pertaining this matter, but it strikes me that he doesn't understand how important it is for the police to have the information he intends to rely upon.
Right.
Yesterday at 5 o'clock, the police still did not have the information which appears before the committee today in the supplementary bundle. So we've all had to, at a very, very late stage in the evening, go through facts which I will say, by way of opening, he's going to rely upon so as to really only facilitate muddying the waters. It matters not. What this committee will be concerned with is the licensing breach.
Point taken.
By this
Alleged
previously.
alleged license.
Okay, this is not going to turn into a crazy day for me today. What I need to do is speak with my legal representative, and we will make a decision. As I said, I'm going to adjourn for the 2 reasons, and that will give you enough time to look through the supplementary. Us two, we've not really seen it, so it does.
The supplementary letters are all the letters that the police have received from us. So there's nothing new in the supplementary.
In the main agenda, we've seen.
But the police, all the letters that are in the correspondence clip are the correspondence between us and the police service. So nothing is new.
No, the letters are not new, forgive me.
Yes, I agree.
The rest is new.
Okay, Stuart?
I just going to reiterate, there's notes for Mr. Dad's about conversations which we can't test. There's various letters in there which got sent to other police officers which we were not aware of. So obviously, although the police had them, we did not.
Right.
Oh, well, that's a fair point.
Okay. Adjourned. Thank you. Yes, could you hand them out? Coming back. Sorry, thank you everyone for coming back. This is turning out to be a tricky situation, and we're not taking this lightly. So I've had conversations we have had with the legal advisor to.
Yes, so the preliminary point that's been raised is about the recording of these proceedings, as already outlined by the chair. Generally, in the default position is that these proceedings are recorded by the council and broadcast on YouTube live broadcast. The issue that's been raised by Mr. Dadds and his client is the opportunity for him to video and record and live stream these proceedings. The facts are that Appendix A in the papers is the application for review, and that is public information being published. Everything else from Appendix B, including CCTV, is exempt information under Schedule 12. Page 7 of the agenda sets out for that. We have sought, following opening this hearing, to reach some degree of consensus amongst the parties as to how we proceed. And the preliminary view of the committee that was raised for discussion was that Appendix A, so the review, in fact, Mr. Officer report, would be public and would be recorded, and the licence holder could video record that part of it, and then the rest of the proceedings would be private. And points were made by the police about the sensitive information and the two potential investigations which take part. Unfortunately, despite an adjournment to see if we could get consensus between the parties, there's no agreement at this stage on that. And both parties have raised with me the importance of the point, and that it is a matter that they will scrutinise carefully moving forward. So I think at this stage, what the committee would like to hear is just some brief submissions on your position and what you want to happen from both the premises licence holder and the police. And then I think the committee are going to take a view as to how best to proceed. They're not going to take that just yet, but they'll ask the parties to go out and have a think. But one of the matters that has been raised is the question of whether we should take a decision on this today, or whether we should take stock and hear in more detail from the parties. So I'm just flagging that at this stage. So I don't know, Chair, if you want to hear from Mr. Dads first and then the police.
Yes, thank you, Chair. Thank you, members. I'll keep it brief. I should be able to do it in no more than 5 minutes. It is an important point, open justice. And I know we're not in a court, but open decision making is really important, even in local government, when we're making a administrative decision. And that the default position, everything should be open. And proceedings should be done in a transparent manner with oversight of the people, i.e. the public, so it can be broadcast. To act as a safeguard for those who have powers, like the police, and decisions of public bodies, like your decision, for example. And no criticism is made of you or in that regard. But nevertheless, your decision is subject to public viewing it, scrutiny, rights and wrongs. And as I say, you have not made a decision, and I've never criticised you or your other fellow councillors in that way. But I'm just saying it should be open so people can see decision making being done in an open and transparent way. Of course, what we mustn't do is to do or say anything which frustrates or renders impractical the administration of justice. So there shouldn't be a sub judice. There is a live investigation. However, there can be, I believe, adequate protections around exclusion. So, for example, you may exclude the public, but not the press. So the press can come in and report, and they know how to report properly without committing contempt of court. Or so there's a question here about excluding the public and excluding the press. A decision to exclude or go into private shouldn't be made to save embarrassment or conceal any facts. And I've already made it quite clear that there is an application already in public, highly critical of the premises, particularly on one point that it is said that CCTV has been refused. And we want to make sure in public all that evidence regarding allowing it to be viewed, allowed to be accessed, to be have and taken, is all open, transparent, because it's a lie to say it's been refused. So in relation to adequate protections, we understand that there should be no discussions around alleged sexual assault. We know there's alleged sexual assault because it's in the open papers. but there are no officers from the investigating team investigating that, as I understand it. I've had no witness statements from any of those officers, and there's no primary evidence before you regarding that actual investigation of crime. So that's not subject to these matters. But even if there were discussions, both counsel are acute to what can be said and what can't be said. In addition to that, if there was anything that needed to be said, that could go into private, part 2. So in part, I accept that some will and ought to go into private. And if you were thinking of viewing CCTV, that should be in private. But the opening for the premise license holder and to make submissions regarding the alleged breach of condition, that should be in open public so that we can address that point openly and with transparently. And in relation to what's already in the public domain, I don't think we need to say anything more about the alleged incident, because we all know it didn't actually happen at the premises, it happened away, and that's been said. And the investigating forces are open, and it's been put into the press. So there's more details in the press than there is in this document, which is quite interesting. So there are, I accept that parts should be closed, but other parts should be open, i.e. allegation of alleged breach. You and I know already, we all know already that the innocence of guilt is not a matter which we determine here. That's for the magistrate's court. There is no conviction. There's no finding of fact whether there is a breach or not, and that wouldn't be for you to determine. In any event, that will be for the court. So they're quite narrow points. So I think that part can be done openly. Now, in relation to going forward, so that's my submission regarding that. Going forward, I think this is an important point, and I think it shouldn't be rushed. I would be quite happy and content for an adjournment so I can make written submissions. I've just done that off the cuff in effect, but full written submissions to the committee why part can be open, part can be closed. And I'm quite happy to do that within the next, I don't know, 2 weeks, 3 weeks, you know, timetabling, and to come back. So I would have thought that would be a practical way forward. But I'm in your hands because, as we know, you can regulate your own procedure and conduct. Obviously, all decisions are open to public scrutiny challenge. And I think it is an important point for my client. My client wants, in 60 seconds, my client was already produced a statement, which was served a week before the request of the CCTV, which was very damning and critical of the police. And that's a document that is going to be heard in public in a hearing. A week after, or within a week, we have all this shenanigans going on in a sense of the request of CCTV. It's a very serious instance, so I don't take any weight from that. And my client has always been willing to assist, and that's been acknowledged. Our client has not refused CCTV and willing to cooperate and assist anyone with alleged serious matters. Our client is concerned about how he's been treated, the premises have been treated, the class of our customers that come. So we think there's a lot more to it. So we want that in public. And it might be that you decide that actually what we say is wrong and you don't agree with us, but at least we've had the opportunity to be heard in public so everyone can see what is happening. And that's all I have to say. I will respect whatever decision you make, but thank you for giving us an opportunity to be heard.
Thank you, David. Thank you.
Mr. Daz has made some really full submissions, and I will try and respond to the submissions hopefully in a chronological way. As far as the licensing legislation is concerned, this committee will be aware where information should not be in the public domain, it can in fact decide that the information must be concealed. So that which has been suggested by way of a default position when information is being concealed, and which in my submission would relate to the allegation being opened and then hearing from the licensing officer himself, and then the hearing continuing from that point onwards in private is what the preferred stance would be. I am somewhat thrown by the submissions that's just been heard, because when we were discussing what Mr. Dadd's, and I say Mr. Dadd's preference for a reason, would be, the suggestion was that he wanted to record the hearing himself, even by way of audio. Of course, police would object to that, as there would be no control as to how that information would be published or where it would be published, or whether in fact it would be annotated so as to conceal identities as well as very crucial information that relate to the two investigations that are still ongoing. That's my first point. My second point is, insofar as the administration of justice is concerned, the committee does have to have a very I'd say easy way of deciding what would be in the interest of justice and what would not. To me, it's quite plain that we're dealing with a licensing offence, and that the licensing offence itself is born out of a breach that occurred, and which is still an ongoing breach that occurred by way of CCTV footage not being disclosed. I will but say that Mr. Dadds has on a number of occasions now accused the police of being dishonest. But when he says that his client has complied with the police's request, he should know that to date, as we're sitting here, the breach is continuing. Not all of the CCTV footage which has been requested has been disclosed. And in fact, that which is not available is quite crucial to the investigation. So I will leave that there.
What investigation, please?
Please, Mr. Dadds.
When we say investigation, I don't want them to mislead you. Which investigation?
Both.
Both, thank you.
Right. Going back to my submission in relation to dishonesty, those allegations, any dishonesty on behalf of the police, very, very serious allegations. And I will but say that it should be relevant to these proceedings in any event. But what we don't have is we don't have anything to back those allegations up. We don't see that there's an independent police commissioner that's been appointed, that there's any investigation report or anything like that. So I would say tread carefully when you hear the word dishonesty, because there's no evidence of that. And then finally, I too feel that an adjournment might well be the way forward. However, what I will say again is the committee should tread carefully. It is important that this matter is heard. It must be heard as a matter of urgency. And the reason for that is that, of course, in the interim, the venue can continue trading. So what I don't want the committee to do is simply fall within a trap, that I would say, of allowing an adjournment when actually the purpose of that is to bypass the purpose of this committee. The matter has to be heard. A decision does need to be made. Inquiries have been made. I will say that. And if it's not appropriate for me to say at this stage, inquiries have been made and a hearing can potentially take place in 2 weeks' time. I highlight that, just also highlight that it is very, very urgent for this matter to be heard. If written submissions has to be provided in interim, that being the fallback position, of course we can comply. But the forward way for us would be to proceed today whilst the information is still being concealed.
Thank you.
It's a very short reply. Just to let members know, to be reassured, and so the public also be assured, is that we have had discourse with the investigating officer, and they have everything they need in relation to what they've requested. And if they require anything more, they will come to us. So the investigating officer of the alleged sexual assault has been in contact and discourse with me multiple times. They have everything that they need. And if they do require anything, they've written to us to say that they will write to us if they need anything further. The investigating officer has said that to me.
Thank you.
Spoke to the investigating officer yesterday, and
yes, let me write this down.
So yes, by all means, Mr. Dadds, write it down. Spoke to the investigating officer yesterday, and as far as I am aware, and from a conversation I had with the investigating officer, the investigation is still very, very ongoing, and that there is CCTV which is still required.
Right, thank you. Is that all submissions? Everyone's happy?
Grateful, thank you.
Yes, thank you. Right, I'm going to, with my members, speak with legal, 5-10 minutes max, and we'll be back and give you a... Thank you.
Can I leave my papers here? I'll take my phone with me.
Thank you. Thank you. Right, thank you for your patience. We've actually had discussions on which way we need to go. So the legal officer is going to give you what our decision has been made for today. Thank you.
Thank you. And the committee's taken some time to deliberate on this particular preliminary issue, which is about the question of what can and can't be recorded of this hearing. Both parties have made brief submissions, but not full submissions on this point, raising issues to do with open justice, what is exempt information, what can and can't be said, and how that should be managed through these proceedings. Both parties have also raised the potential importance of this particular issue as to what can and can't be recorded, and both parties have raised the prospect of an adjournment in relation to on the point. In addition, the police have raised the degree of urgency in this review being considered sooner rather than later, given what's the committee's had consideration to all of those factors and has decided to adjourn this hearing to allow written submissions to be made. Part of the reason for that is also to provide a proper reasoned decision on this issue, having heard considered written submissions from both parties. With the police's views in mind as to the degree of urgency in hearing this sooner rather than later, the committee have looked at dates when they can reconvene, and the date which they can reconvene on is the 3rd of May, so that's Wednesday the 3rd of May. What the committee direct is that the premises licence holder will provide written submissions by 5 p.m. on the 26th of April. Then the police will provide any written submissions on this point by 10 a.m. on the 2nd of May. And then we will reconvene at 11 a.m. on Wednesday, the 3rd of May. I hope it's immediately apparent to everyone that that is quite strict in terms of timings, but it does allow some time for the committee to consider the written representations. On the 3rd of May, what is envisaged is that both parties will make some brief final points on their written submissions before the ruling is given, and then whatever that ruling is, we will proceed on that day. Does anyone have anything to say? Mr. Dadds wants to say something, but that's the ruling. Just one moment, please. Have you nearly finished? I have finished, that is it. Lovely. Mr. Dadds.
Thank you, Chair. Thank you for taking the time to consider. I have a couple of points I wish to make. Firstly, I think it should be a date that we can all agree to. So I would need to check availability for the 3rd. I can do that pretty much instantly. In relation to exchange, I don't think it's fair that I should have the response on the 2nd to then come in the next day to deal with it, because I don't know what the police are going to say. They will obviously have had my written submission at least a week before. The degree of urgency I don't share for the reasons I've already said, but I know that I don't think we've got elections here in, I don't think you've got elections here in Nurm, have you? So the committee stays the same.
But we do have 3 bank holidays within May, and the reason why we've come up with such a stringent timetable, and we have given both parties 6 days each. You yourself will have 1 day. Admittedly, you don't know what they're going to come back with, but you will have an opportunity, as legal has said, to add any, not new, but maybe if there are any comments or things that need to be addressed, you do have, and we will give you a brief amount of time to come back on the 3rd. The reason being also is that there are holiday restrictions, and we've actually managed to, going back, you said it's only like 1 day for you to look through everything, but it's the same for us 3.
But I have to respond. Look, Madam, I can just, Chair, sorry. I will do my utmost, and I'm sure I can, although I'm away this weekend, but I will start to draft a written submission for the 26th. But I think both parties actually know what the arguments are. So my view is actually there could be, even if it's pushed by a simultaneous exchange of legal arguments on the point on the 26th, and then leave it to the 2nd of May for anyone if they want to add anything further or rebuttal. So I think actually, because it's an issue of openness, both parties should make a submission by the 26th. Any additional points that are new, that either party by the 2nd, ready for the 3rd. And I think that would probably be fairer for everyone, because at the end of the day, the points are known what we're arguing.
Yeah, what I suggest is to hear from the police on that. If they are, that I can see that the force in that, because then there's a mutual exchange on the 26th. So that's 6 days from now. And if anyone has any final comments, they come in by 10 a.m. on the 2nd. Can I say the committee's been very clear with me, and I pass that on, that there has to be strict adherence to those times and dates.
Yes.
We don't want documents coming in last minute.
I have no real preference personally. It strikes me, however, that it is probably better to know what we're arguing and that there is an opportunity to come back in case there's something new. So I'm quite happy to agree that submissions can be done on the 26th of April by 5 p.m. And then that if there's anything that needs to be come back by way of a mutual exchange, that can be done by, should we say, 10 a.m. on the 2nd of May. So we keep to the same timeline. It's just that the committee also will have more time to read both party submissions, really. That might be better, actually, to allow you some more time as well. So I'm quite happy with that.
So, Madam, subject to your view, that sounds sensible. So mutual exchange on the 26th of April and any final submissions by 10 a.m. on the 2nd of May. We had discussed 3rd of May at 11 a.m. You will have had a bit more time, so you can go with 10 a.m. if you'd like on the 3rd of May. Mr. Dads, are you available on the 3rd of May?
I'd need to check. I haven't done. I've been listening. Oh, sorry. But also, what we could do is make sure the local authority have our submissions, so that on the 3rd, on the 26th or the 27th, you'll receive it, so you can read that, and yes, any supplementary will be given to you on the 2nd of May.
That's what
yes. We'll mirror filing and serving in the same way. So, yes. Okay.
Yeah, so that's so I was just making sure that's clear. We're not just doing it mutually between us, but so I would welcome. I would probably welcome 11 a.m. start, because if there's anything new, I can then take instructions and not having to meet the night before or whatever, but I will now check quickly if I'm free on the 3rd or whatever's there, I can move. So could I just step out from it and make that call?
Yes, you can.
Thank you.
Thank you. Do I need to go anywhere? I just let him go.
Okay.
Yes, thank you. I do have something in my diary for the 3rd. However, I believe I can get someone instructed or someone to move that. So I can do that.
Wonderful, thank you very much. Anything further to be added?
Yeah, 11.
11.
Just quickly, sorry. No, go on.
And the committee just asked me to be very clear that those timings, so 5 p.m. for mutual exchange on the 26th of April and 10 a.m. for any rebuttal submissions on the 2nd of May, those are fixed. If anything comes in after those, they're unlikely to be accepted by the committee.
Yes, you're looking at me, but but I have got to note, God willing, I intend to progress it as you've asked.
Okay.
But just quickly, can everything be sent to me directly? Then I can distribute it to everybody.
Yes. If I send it to you, Mr. as well as maybe a legal advisor, so there's 2 addresses in case you're not here or something like that. So, God willing, you'll be here. So I think really, if I've got 2 addresses, I could send it to Sheila.
Yeah.
Yeah.
So perhaps we could send it to Mr.
Yes.
Songa.
I'll deal with that through the.
Yes. Okay.
I think.
Thank you. So we'll do that. Thank you very much for your time this morning.
Thank you.
Forgive me for being pedantic, but it still really circles around this issue of privacy. So the hearing that we will have on the 3rd of May, I'm conscious that if we don't arrange for the same to be private at this stage, that we'll be having an argument about the privacy of that hearing also. So I would perhaps invite the committee to give a direction that the privacy of that hearing also needs to be addressed within the actual submissions that's made, so that we don't then face a further adjournment, as what needs to be addressed by way of the police may well fall within the scope of information that should be protected.
All right.
Chair.
2 decisions to be made is what I'm saying.
Chair, it's much simpler than that. We're going to make legal submissions regarding the principal hearing on the 3rd. The arguments regarding open justice and those submissions should be in open. We're not going to be discussing any facts. We're going to be arguing about open justice. So I think that should be the argument about whether we should have it in public or private, or the press should be excluded, should be an open discussion. We're not discussing the offences,
or anything that has been submitted.
I think from the legal perspective, I think the parties can be sensible about brief submissions made on the 3rd of May, referable to their written submissions. And I think we can have that, and we probably should have that openly dealt with.
Any further questions? This meeting is adjourned.